Christian Robbins with ZAMP HR. I'll be your presenter today for the Supervisor Sexual Harassment and Abusive Conduct Prevention Training. So my experience comes from about 4 years working with ZAMP HR as a senior HR and risk manager. I've also been regional operations manager for a large distributor for the Western United States, was director of HR Safety and Workers' Comp for a heavy casting foundry, and had several other roles for safety and HR over the last 25 years. I was a lecturer at Unimonte, a state university in Brazil from 2004 to 2006. I've owned several businesses, and for the last 15 years, I've specialized in making workplaces more productive by changing culture and increasing employee satisfaction and performance. So, broad scope of experience from foundries to construction to software, and fluent in English, Portuguese, and Spanish. So, like I said, today will be the California Supervisor Sexual Harassment and Abusive Conduct Training. And we're going to pursue the following objectives. During this training, we will show a supervisor how to understand the elements of sexual harassment, understand the personal liability they have as a supervisor, know the remedies that are available to victims of sexual harassment under California and federal laws. We'll discuss other forms of unlawful harassment and how to stop them, and we'll also consider strategies for preventing and responding to unlawful harassment and any concerns regarding abusive conduct in the workplace. Now, as a supervisor, you have special liability. Under the FEHA, individuals can be personally liable for sexual harassment. And the people that are protected under the law, being the FEHA, are employees, applicants, contractors, volunteers, unpaid interns, and clients. So, every employer or prospective employer is liable under the law, and every person in the workplace, so supervisors, subordinates, co-workers, any of those that are found liable for sexual harassment, they can be personally liable for the damages caused by that unlawful harassment. Personal liability of the harasser. The individual harasser is personally liable for the damages caused by his or her unlawful actions. Okay, in the case of a supervisor, the supervisor is strictly liable for the unlawful harassment by you, the supervisor, and any agents of the employer. So let's talk about the liability of the employer and supervisor. A supervisor, for the purposes of the California Fair Employment Housing Act, or FEHA, is if they have discretion and authority. So, authority to hire, authority to transfer, authority to promote, authority to assign to a position or a post, authority to reward, authority to discipline, authority to discharge. You can also be liable or held as a supervisor if you recommend any of these actions. So, if you are an HR consultant and you recommend any of those actions, you have now made yourself a supervisor according to the California Fair Employment and Housing Act. B, to act on grievances of other employees or effectively recommend action on grievances. So if you have the authority to act on a complaint that an employee has brought against the company, or if you're in a position to recommend action, you have liability as a supervisor. And C, to direct the claimant's daily work activities, which is the normal definition of a worksite supervisor that we normally work with. So there's also harassment by non-supervisory employees, and employers can be liable for harassment by non-supervisory employees. if the employer knew, or if it's demonstrated that the employer should have known about harassing behavior and failed to take immediate and effective corrective action. So the two forms of sexual harassment that we'll be going through today as supervisors are the same two that we went through as employees, and it's defined by case law as quid pro quo or hostile work environment. Quid pro quo is this for that. So demanding sexual favors in exchange for employment benefits. So that could be, hey, have sex with me and I'll give you the job. That could be, have sex with me and you'll get a promotion. Or you can also demand sexual favors by threatening negative employment actions, like if you don't have sex with me, I'll fire you. If you don't have sex with me, you'll have to work on the night shift and take a $2 an hour decrease in pay. Those are quid pro quo. So we're trading sex for something at work. Hostile work environment sexual harassment is a little bit different. And it can be harassing behavior that's directed towards the person bringing the complaint, the complainant. It can be harassing behavior that's witnessed by the person that brings the complaint, the complainant. Or it can just be widespread sexual favoritism that infects the workplace, creating a hostile or abusive environment. And we'll explore some scenarios that talk about these individual as we get through the rest of this. So here's the remedies. Injunctive relief. So under the FEHA, they can actually get a restraining order against the business, and they can require that the business do several different things. Training or development of policies or changes of policies and procedures would be the first things that they start with. The other remedies that we would look at, so economic damages, this would be some form of a settlement. So if someone's lost wages because of harassment, or incurred medical expenses because of harassment, or had to look for a new job, or were looking for a job and the potential employer was the one found guilty, then there could be job search expenses. So all those are monies that will be paid out. There's also non-economic damages, and those might also come to the point of a settlement. There might be a monetary value for emotional distress. There might be a monetary value for the loss of enjoyment of life. Okay? And there could be punitive damages, which would also be a monetary settlement. So there's a lot of remedies out there, but really what we need to know is any of those things can end up costing an employer and the supervisor independently can end up costing them money. So the California FEHA has 17 protected classes, and that's in comparison to the federal Title VII protected classes, which there are 8 of. So under the California FEHA, race, color, national origin, sex, sexual orientation, gender, gender identity, gender expression, religious creed, mental disability, physical disability, a medical condition, a military or veteran status, marital status, age, genetic characteristics, or ancestry can all be a protected class. Under Federal Title VII, the protected classes are race, religion, gender, national origin, age, disability, genetic information, and military or veteran status. So, quite a bit more protected classes under the California FEHA, and we'll kind of look at those as we continue the presentation. So, let's look at quid pro quo and what it exactly means. These are facts regarding quid pro quo sexual harassment under the FEHA. So it's the promise of reward or the threat of punishment in exchange for sexual favors. It does not need to be explicit in order to constitute quid pro quo sexual harassment. And that just means it can be inferred. So you can say, hey, if you'd like to get the job, why don't we go out to dinner and then see what happens? Wink, wink. So that would be inferred, and that can also be quid pro quo sexual harassment. Does not have to be explicit. An employee who gives into the demand for sex in order to avoid a negative consequence has not forfeit his or her claim for quid pro quo sexual harassment. So you can have someone that says, I'll give you a promotion if you sleep with me, and so then the sex happens. They can still come back and claim quid pro quo sexual harassment and sue you for it. A claim for sexual harassment can still be successful even without a neutral witness or documentary evidence supporting the claimant's accusations, even if the alleged harasser denies the charge. So that just means there's going to have to be an investigation, and if there's circumstantial evidence, a claim for sexual harassment can be successful, even when the alleged harasser denies the charge. And there's a couple of scenarios in this presentation that we'll talk about that specifically. So quid pro quo explained. It's just the essence of a quid pro quo sexual harassment claim is that a supervisor relies on their authority, and that's apparent authority or actual authority, to extort sexual favors from an employee. And the threat may be expressed or implied. Had an individual that worked for me at one point. He was managing a night shift, supervising a crew on that night shift. He had probably 10 employees that were under him. So they were a mix of regular employees and temporary employees. And there was a temporary employee that he was interested in sexually. And so he invited her to, I believe the term that he used was, we should hook up, and invited her several different times via text. And later that morning, after they got off work, it was brought to my attention by the owner of the temp agency for which that employee worked. She had taken the text messages to her boss at the temp agency, who showed them to me. And so I called the employee in and talked to him about the text. So he claimed it was consensual, but in the text I could see that it wasn't. He claimed it was after work because they were already off work. They were already punched out, so it was nobody's business. And that doesn't work, because what he had offered was, if you give me sexual favors, I will put in a good word with the boss and get you hired here as a regular employee. So that is the essence of quid pro quo. Even though he didn't actually have authority to hire, he used his apparent authority and attempted to extort a sexual favor from, and in this case it was a temp employee. So the threat can be expressed or implied, like I talked about earlier. It doesn't have to be that direct. It can be, hey, how about we go out for drinks and see where things go? If the evening ends well, then that promotion will come right through. So that would be just implied. So here's an example of quid pro quo sexual harassment, and we'll kind of go through some of these scenarios. Rob, he's a sole proprietor. He wants to expand and compete for state contracts. So he brings on Jack, who's an independent contractor. He installs a computer network, puts an ad up there for an office manager. Mary responds to the ad. And so Rob, he's feeling pretty good about expanding his business, and he threatens to sue Jack for breach of contract unless Jack agrees to engage in sexual activity. And he also tells Mary that the job is hers, that he will hire her if she agrees to have sex. So let's talk about what the consequences are and what could have happened here. So in this case, in that example in the previous slide, Jack and Mary can both sue Rob for quid pro quo sexual harassment because he had said, hey, I'll give you this in exchange for sex. So in Jack's case, it was, I'm going to sue you unless you give me sex. And in Mary's case, you'll get the job if you give me sex. So here's a scenario for discussion. So Sarah, she is the deputy director of a state agency, and she approaches Nancy, who's an office technician. She says, hey, Nancy, seen you at the gym. You seem to have a great time in Zumba. So sexy. Nancy, I'd love to take you to Tahoe this weekend, just the two of us. Well, Nancy, she's stunned and intimidated by this attention, and she says, well, Sarah, I'm flattered, but I'm not interested. Sarah smiles wanly and says, well, I had to ask. You are just so sexy, but I get it. I'll leave you alone. So Sarah doesn't proposition or engage any unwelcome conduct toward Nancy again. Okay? Scenario happens. 3 months later, Nancy's late to work for 3 days, and her supervisor threatens to deny her MSA if she's late again. So let's talk a little bit about this and ask some questions here. Under FEHA, can Nancy establish a claim for quid pro quo sexual harassment because Sarah should have never asked a subordinate on a date? Well, the reality is you can still ask a subordinate on a date. But it is very, very complicated because of everything that's at stake. What happened there was, hey, let's go to Tahoe, and Nancy said, no thank you. And then Sarah left her alone completely. So once someone states no thank you, or no, or stop, or any of those things, if it's never revisited, it is really not harassment at that point. Doesn't mean somebody can't sue you for it. It just means that the claim would be weak. Now, the second question, there is no claim for quid pro quo sexual harassment because there's not evidence that Nancy is a lesbian. Wouldn't play into this at all, whether she is or is not. That last question there, or statement rather, it's a weak claim. There is no evidence that there was benefits being offered if she said yes, or punishment if she said no. And that's really what we want to look at is there quid pro quo? Is there a benefit for saying yes or a punishment for saying no? And in this case, there wasn't. The fact that she came in late 3 days in a row and had consequences for that would not have anything to do with their initial interaction where she was commenting on how sexy she looked at Zumba. So, hostile work environment, let's take a look at those scenarios and talk about what makes a hostile work environment. So we've talked about quid pro quo. Now we'll talk about hostile work environment. We'll revisit both of them as we go on. To prove hostile work environment, sexual harassment, the complaining party does not need to show that they suffered an adverse employment action. So that just means that they don't need to show that they lost money, that they lost time, that they lost wages, that they were terminated. They don't need to show that they suffered an adverse employment action. To prove hostile work environment sexual harassment, the complaining party does not need to show they were subjected to severe or pervasive unwanted sexual attention either. The law in California does not state that it has to be severe or pervasive, just that it has to exist. So, the courts recognized the 3 different varieties of hostile work environment sexual harassment. And one is conduct directed at the claimant, so the person filing the sexual harassment claim. The second is conduct directed at other people other than the person filing the claim, and they may be filing it on their own behalf or on behalf of other people. And widespread sexual favoritism would be the third. Harassing conduct, There's verbal, visual, physical, and those are all harassing conduct. Verbal would be foul or obscene language. It could be explicit discussions about sexual activities. It could be derogatory comments about someone's sexuality. It could be derogatory comments in general, comments about other people's physical attributes. All those would be considered verbal hostile work environment. Visual can be another thing. Leering, which just means kind of that sideways glance, suggestive glance, and they call it lascivious, revealing an overt or often offensive sexual desire. That leering is one to stay away from. Staring, people that are staring all the time at coworkers or subordinates, that would make a hostile work environment. Making sexual gestures, and that can be with the body, with the hands. Displaying sexually explicit objects, pictures, cartoons, graffiti, posters, and sharing graphic emails, text messages, or jokes. So the last one would be physical, kissing, hugging, grabbing, impeding or blocking movement. That can also fall under the prolonged handshake, where somebody holds your hand and doesn't let you move past them. Assault is one of the other things. And remember, whenever you touch another employee, it is assault. So here's a scenario for discussion. Tamika, she's starting as a supervisor for the commission in Yuba County. And 4 other supervisors and all the field crews at Yuba County are men. Eve is the district administrator, and she doesn't think women should be field supervisors. She resents that headquarters has forced an affirmative action case on her. So Eve tells the other supervisors and the crew members, hey, the field is no place for a woman. She tells Tamika's crew to keep an eye on her and to use their own judgment in the field. During office meetings and around the office and in emails, Eve refers to Tamika as the little one, Wonder Girl, Oprah Jr., and similar type names. Tamika tells Eve that she's undermining her, but Eve tells her, grow a pair or you'll never make it out there. Well, here's some questions that we can consider. Are Eve's use of diminutive nicknames and undermining of Tamika's authority okay? Because Tamika needs to demonstrate the ability to supervise men in what can be an inherently crude environment. The reality is Eve is undermining Tamika's authority. Have Eve's nicknames and statements undermined Tamika's authority created a hostile work environment? Yes, it has. Here's something to consider, though. Because Eve has not shown interest in Tamika sexually, her hostile behavior is not actionable as sexual harassment. Well, the nicknames and statements were sure that they've undermined Tamika's authority and created a hostile work environment. But is it sexual harassment? And in this case, we know it is because Eve stated that the field is no place for a woman. And so she made it about Tamika's sex. Here's another scenario, and we're continuing on with Tamika's crew. Warren, he frequently refuses to follow her orders, saying, hey, your boss told me to use my own judgment. Warren and Ben, they interrupt team meetings by burping, talking, and laughing. And then they insincerely offer apologies, saying, apologies to your ladyship. Well, Frank, who's another crew member, he tells Warren and Ben, leave my gal alone. And he repeatedly comments on Tamika's appearance, saying things like, you're the hottest boss I ever had. Dollface, you can tell me what to do whenever and wherever you want. He repeatedly asks her out, even though Tamika makes it very clear that she's happily married and doesn't want to go out with him. Here's the problem. Tamika's afraid to call Eve about the behavior because of Eve's treatment of her. But she does send her an email about the treatment by her crew. Eve never takes any action on the complaint. So let's talk about, let's ask some questions and talk about some scenarios here. So Frank is the one saying she's the hottest boss ever. Can Frank be found liable for hostile work environment sexual harassment? Has he overstepped the lines there? Does the fact that he defended Tamika make a difference? No, it doesn't. Could he be found liable for hostile work environment sexual harassment? In his case, it would be harder to prove, but he could be. Warren and Ben cannot be liable for sexual harassment because there's no evidence that their disruptive actions are substantially motivated by Tamika's sex. We don't know. Would they be the same way under a male boss? It would be hard to say. Does it matter that under the FEHA their actions are neither severe nor pervasive? Or do they just have to do the wrong thing? And is the employer liable for sexual harassment of Warren, Ben, and Frank because management knew or should have known of the behavior? Well, I think there we have the best answer, because Eve received a written complaint from Tamika regarding all of her crew, Warren, Ben, and Frank. And management should have done something about it, and they knew about it, or in this case, they should have known about it and did nothing. So now they're liable, and Eve is also liable. So there's a couple of different tests. When it comes to sexual harassment quid pro quo, it does not need to be severe or pervasive. But for it to be an abusive work environment, it does have to be severe or pervasive. So to be actionable, the unwanted behavior must be severe or pervasive and alter the conditions of employment to the extent that it creates a hostile or abusive work environment. So in a hostile work environment, it does have to be severe or pervasive. Solicitation of sexual favors, quid pro quo, it's always actionable. And we talked about that because it does not have to be express, it just has to be implied. So the things that we consider are the nature of the conduct. So how often are these guys interrupting and burping? Those are the couple things that we look at. The period of time over which it occurred. Has it been always? Have those guys always been jerks? Did it just start under Tamika? Whether the conduct was physically threatening, humiliating, or of a sexual nature will also come into it. And the extent to which the conduct unreasonably interfered with an employee's work performance. Did the meeting still get completed? Was the meeting not finished because of the interruptions, the burping, and those type of things? Those would all be taken into consideration in this case. Here's a new scenario for discussion. So this is about Cody. He's a supervisor for a company called The Board. Drew, he's an office technician. He sits in a row of 5 open workstations right outside Cody's office. Drew's first day, Cody gives Logan, another office technician, a lingering hug and a kiss on the lips. Cody says, while looking Drew up and down, "Welcome to Cody's world. If you remember just one rule, what Cody wants, Cody gets. You'll have a bright future here." So the next day, Logan, and this is not Drew, Logan, another employee, he gets to work very early. He was the one that got kissed the day before and gets seated before Cody arrived. We can assume that was so that he wouldn't get grabbed and hugged and kissed by Cody. But Cody comes and starts rubbing Logan's shoulders and says, "Hey, you can't stay seated forever." So Drew sees and hears these interactions. Logan tells Drew what's happening, and Drew says, "Get over it." Drew starts losing sleep and misses work because of Cody's mistreatment of Logan. Let's talk about some questions here. Can Drew claim hostile work environment even though Logan told him not to complain. Since Drew has personally witnessed Cody's harassment of Logan, can he sue Cody and his employer for sexual harassment due to a hostile work environment? Well, the reality is Drew personally witnessed Cody's harassment of Logan, and therefore he can sue Cody and his employer for sexual harassment due to a hostile work environment. He was not harassed directly, but the fact that he presenced the harassment of his coworker Logan gives him that right. So let's continue on with Cody, because Cody's pretty rowdy at work. Cody and two other office technicians, Parker and Rachel, are openly in a sexual relationship. So obviously it's consensual, it's open. Cody regularly calls them to the office for special consultations. Their sexual congress is audible through the door. Cody gives Parker and Rachel preferred shifts, bonuses, and training that he denies to others. Cody allows Parker and Rachel to use Drew, Logan, and another employee called Timothy to do their personal work and to run their personal errands. So there's not much responsibility for Parker and Rachel because they are in a sexual relationship with their boss, Cody. Drew, Logan, and Timothy are all disgusted, but they work together to make sure that they excel at their assignments. Can Drew and Logan claim sexual harassment, hostile work environment, widespread sexual favoritism? Yes, absolutely they can. Timothy, even though he's never been harassed to our knowledge by Cody, can he successfully claim sexual harassment, hostile work environment, widespread sexual favoritism? Absolutely he can. So in this case, Drew, Logan, and Timothy, do you think they can successfully sue Cody, Parker, and Rachel, and the employer for sexual harassment? Yeah, he can sue all of them. Can Parker and Rachel sue Cody and their employer for sexual harassment, hostile work environment, widespread sexual favoritism? Well, in the widespread sexual favoritism, they'd have a hard time because they're the ones engaged in a relationship with Cody. To our knowledge, there was no quid pro quo, but there may have been. We just don't know. So the best answer for right now is Drew, Logan, and Timothy can successfully sue Cody, Parker, and Rachel and their employer, the board, for sexual harassment, hostile work environment, widespread sexual favoritism. Let's talk about some key concepts here. So, key concepts of the FEHA. Sexual desire is not a key element to any claim for sexual harassment. And an employee can file a claim for sexual harassment even if the supervisor took no adverse employment action. They weren't termed, there was no failure to hire, there was no demotion, no loss of income, no shift change, etc. Anybody can file that claim for sexual harassment. Sexual desire does not play into it at all. And recent legislation was clarified existing law by expressly stating sexual harassing conduct need not be motivated by sexual desire. Adverse employment action is not required, as we just talked about. The complainant does not have to have a tangible economic loss or any other adverse employment action. The crux of a harassment claim is the assault on the complainant's personal sense of dignity and well-being. So let's talk about some denials and defenses. Here's a fact for FEHA. In California, the employer is still liable even when the employee does not use the established internal complaint process, even if the harassment would have been eliminated had the employee alerted the employer via the internal complaint process. And kind of what that means is, we'll talk about denials here, and we'll go into a scenario about that. But here's typical denials. It never happened. There are no witnesses, so it never happened. Look how she dresses, so she wanted it because she's dressing that way. I'm a hugger. I can't help it. And then, have you ever heard of a woman scorned? If I don't say she's hot, She's not going to get the job done. Well, let's talk about the scenario here. Sam is a senior supervisor for the department, and he calls Maggie into his office. He says, hey, it's your performance review. It's not going to be good. It's going to be substandard unless you engage in a sexual act with me. And then he grabs her and pushes her to the ground. Well, Maggie escapes Sam's grasp and flees from his office. Jose sees Maggie running out of Sam's office in distress, notices that her blouse may have been partially off. Katie sees Maggie in the restroom, sees her crying and fixing a tear in her blouse. Then Maggie tells Katie about the attack. Well, Sam abruptly promotes Maggie. Katie and Jose tell an equal employment opportunity officer what they saw and heard. Sam denies everything that happened. Maggie files a complaint with the California Department of Fair Employment and Housing alleging quid pro quo sexual harassment against Sam. Let's talk about some questions. Well, Sam's a senior executive, so will everyone believe him when he says Maggie is a liar? No one actually witnessed the alleged unwelcome conduct. Will no one believe Maggie? Because Maggie was promoted, she didn't suffer damages. She was actually promoted, so there can be no claim for quid pro quo sexual harassment. How about this? Would a reasonable investigator conclude, based on circumstantial evidence and credibility assessments, that quid pro quo sexual harassment occurred? The reality is that a reasonable investigator would conclude, based on circumstantial evidence, so Jose seeing her run out with a ripped blouse, her other friend talking to her in the restroom and seeing her fix her blouse, as well as credibility assessments, so further interviews with them, past performance appraisals, other people that the supervisor had interviewed, and see quid pro quo sexual harassment did occur. So there's also the defense of the lack of action by the victim. And this is one we'll talk about a scenario, but in some cases a victim could have avoided part or most of the harm if they'd taken advantage of the employer's procedures for addressing sexual harassment. And that's what we call the avoidable consequences doctrine. The amount of harm to the victim could have been less if the employee had taken action and failure to mitigate damages. Here's a scenario that talks about that. ABC Code, they provide an employee handbook that details zero tolerance for sexual harassment. And it tells employees to call the HR department immediately if they experience or witness any sexual harassment. Well, Quinn, he's a supervisor, and he works with Pat. Pat's one of his subordinates. And he walks by Pat's desk and whispers to Pat that Pat should forget to wear undergarments the next day. Pat just pretends not to have heard him. But from then on, Quinn whispers similar comments to Pat at every opportunity that they're alone in the office. Pat doesn't do anything at the time because he just knows that it's a matter of time before Quinn, who's an incompetent supervisor, will be replaced. So 6 months goes by, Quinn's terminated for poor performance, at which point Pat recounts all of Quinn's past actions to a senior executive and asks the manager to make sure the next supervisor is less disgusting. Okay, since 6 months have passed, can Pat sue anyone for sexual harassment? Pat waited until Quinn was fired before sharing anything with management. Has he forfeit his right to sue Quinn or the employer? Can Pat sue both Quinn and ABC? ABC may try and reduce the amount by arguing, hey, the harassment would have stopped if Pat had called HR after Quinn's first comment. Pat can only bring a claim against Quinn because Pat chose not to follow the instructions in the employee handbook, ABC is not liable. So ABC is still liable because the California FEHA says, should they have known, or they have known, or should have known. And the truth is, they should have known. ABC can try and reduce their exposure by arguing that the harassment would have stopped if Pat called HR after Quinn's first comment, but Pat can still sue both Quinn personally and ABC as his employer. Let's talk a little bit about federal and California state sexual harassment laws. Under the FEHA, unpaid interns and volunteers are specifically protected. They are not specifically protected by federal sexual harassment law. The California law is substantially broader than the federal law in providing protection against sexual harassment. And here's a quick comparison of the two. Federal Title VII, you just have the negligence theory only. The employer is not automatically liable. The California FEHA, strict liability. The employer is automatically liable for harassment by managers and supervisors. Under Federal Title VII, the employer is not liable if the employer exercised reasonable care, the employee unreasonably failed to take advantage of opportunities to avoid harm. So that would mean they did training and they had a complaint process by which the employee could have ended the harm. Under California FEHA, the employer has no defense if a manager or supervisor is a harasser. In Federal Title VII, it applies to companies of 15 employees or more. Under the California FEHA, it's all employers, even those employing one person or a sole proprietor. Under Federal Title VII, no application to independent contractors, volunteers, or unpaid interns. And California expressly includes contractors, volunteers, and unpaid interns. Let's talk about a couple of other types of harassment. So California law identifies 17 specific protected bases for employment discrimination, harassment, and retaliation. Sex, sexual orientation, gender, gender identity, gender expression are all protected bases under the FEHA. A few more things that we're going to look at as far as illegal harassment, discrimination due to protected class or status. This goes through a couple of those things. We're going to talk about racist conduct, though, the use of racial terms, name-calling, racial figures of speech, cultural joke-telling, racial joke-telling, segregating employees based upon race, making fun of coworkers or foreign accents, sexual orientation, teasing, taunting an employee for real or perceived sexual orientation or gender identity, name-calling, gossip, saying are they or aren't they, and related to their sexual orientation, religious issues, making negative comments about particular religious belief or practice, inappropriate conversations in the workplace on religious topics that may alienate people who do not share the same belief, proselytizing or trying to persuade people to join your religion at work. Additional harassment, discrimination due to disability, gender, association, and age. Disability-based harassment, that could be isolation, teasing, patronizing comments, refusal to reasonably accommodating but putting conditions to that accommodation, teasing or taunting for gender association, for people that are in roles that were historically dominated by another gender, gender assigned job titles, that would be titles like mailman, we would now call them mail carriers, passing up an individual for promotion based on their gender identity or lack of if a supervisor is not comfortable with the gender they decide to assume at work. Age-based harassment, negative comments or references based on age. So that would be calling somebody grandpa or youngster, inappropriate isolation or exclusion, gestures to imitate, unfair criticism, physical harassment, violence or threats of violence, horseplay, destruction of property. And remember that anytime you touch another employee, that is considered assault. Personal harassment, verbal harassment, and this doesn't have to be based on a protected class. It just has to create a hostile work environment. So it can be jokes, public humiliation, intimidation tactics, ostracizing behavior, any type of bullying, yelling, cursing, and just basic mean or unpleasantness. And then there's always the power harassment. Even when it's not sexual, it can be power harassment. So that would be a boss or a manager to a subordinate. Someone that just has perceived power, like in the scenario that we talked about earlier, making impossible demands on employees, humiliating employees in front of other employees, bringing their personal life into the workplace. Psychological harassment, you can make them a pariah, ostracize them, make it so that nobody else likes them, gossip about them, isolate them, talk down about their contributions, belittle their ideas, and use other types of intimidation tactics. There's cyber harassment, where mass humiliation of employees, false claims on social media, cyberbullying. There's retaliation. So this would happen if an employee reports a supervisor for doing something wrong. The supervisor wants to get payback or revenge. Tit for tat, that means you did this to me, so I'm going to do this to you. You up the ante. So, you're going to say this about me? Well, I'm going to say this about you, and it's 2 times worse. Third-party harassment, that's when you have vendors or suppliers or customers or clients that are the harassers. These are the 17 points that are under the FEHA again: race, color, national origin, sex, sexual orientation, gender, gender identity, gender expression, religious creed, mental disability, physical disability, a medical condition, military or veteran status, marital status, age, genetic characteristics, and ancestry. Finally, another scenario for discussion. So Carl, he's been a manager over at the board for 5 years. And he approaches another manager, Terry, and tells him that she identifies as a transgender woman and is beginning the process of transitioning at work. So from now on, Carl says, I would like to be called Kay. I'll be wearing clothing consistent with an identity as a woman, and I would prefer the use of feminine pronouns. Well, as the weeks pass, Kay's coworkers become accustomed to her new name and appearance. Some of them still inadvertently refer to Kay as Carl, and sometimes use the masculine pronoun he, especially when telling stories about things that happened before Kay's transition. Usually, though, the coworkers are quick to correct themselves when this happens. Terry, however, he pointedly says, "Good morning, Carl," when Kay passes by, and makes comments like, "Nice dress, dude." Well, Kay is embarrassed, but says nothing to Terry or anyone else about the comments for months. So let's talk about some things. Should Kay just keep her head down and try and focus on work? Not everyone's going to be comfortable with the gender transition, and she should probably just expect some negative comments and remarks. Kay has a claim for discrimination and harassment because of the gender identity and gender expression against her employer because Terry's negative comments and purposeful repeated use of the wrong name and pronouns. Yeah, in this case, Kay would have a claim for discrimination and harassment. Does Kay have a claim for discrimination or harassment against her coworkers since they occasionally use the wrong name and pronoun? No, in this case they don't, because it's not something they do on purpose or they do all the time. So should K's coworkers be officially reprimanded and notes placed in their files? No, in this case they wouldn't need to be, because they are respecting K's wishes and using the proper pronouns that have been assigned by her. So K does have a claim against Terry and the employer, the board, because of Terry's negative comments and purposeful repeated use of the wrong names and pronouns. The coworker's occasional and accidental mistakes don't create a situation of discrimination or harassment. Typical harassment cases are employees are fired or denied a job or a benefit because they refused sexual favors, or they complained about harassment. That is quid pro quo. Remember, something for something else, and it's usually something for sex. Retaliation for complaining about harassment is illegal, even if you can't demonstrate that the harassment actually occurred. So that would be the person that's denying it. An employee quits because they can no longer tolerate an offensive work environment. That's referred to as a constructive discharge harassment case. So if a reasonable person under like conditions would resign to escape harassment, the employer could be responsible for the resignation of the employee, as if the employee had been discharged. An employee is exposed to an offensive work environment, and that's exposure to various kinds of behavior or unwanted sexual advances. Just that in and of itself may constitute harassment. Preventing and responding to sexual harassment. So the DFEH, Department of Fair Employment and Housing, they can seek injunctive relief, like an extraining order, to compel employers to take all reasonable steps to prevent unlawful discrimination without proving an underlying violation of the FEHA. The employer's duty to take immediate and effective action in response to a claim of sexual harassment applies in every circumstance, and not just where there's a credible report or threat of unwanted physical contact. More FEHA facts. Employers have to take all reasonable steps. It's unlawful for employers to fail to take all reasonable steps to prevent discrimination, harassment, and retaliation. Discrimination as to whether an employer has complied with the government code, Section 12940K includes an individualized assessment dependent upon the numerous factors unique to the particular employer, including but not limited to workforce size, budget, nature of the business, and facts of the case. So always make sure that as a supervisor, manager, employer, that you're taking all reasonable steps to eliminate discrimination, harassment, and retaliation. So the employer is obligated to conduct an effective workplace investigation of a harassment complaint and should always conduct a thorough interview with the complaining party, give the accused party a chance to share their perspective of the events, and interview any relevant witnesses. As the investigation is being done, you want to obtain all relevant documents, investigate all relevant avenues applicable to the allegations, and reach a reasonable and fair conclusion based on the facts. We always want to make sure that as a supervisor we have specific protocols to follow when we're accused of harassment, and those would include things like do not change your behavior with the person that you are harassed by. If we can, we want to put supervisors in places where they won't be supervising the person that's accused them of harassment until the investigation has concluded. So we want to make sure that we provide a little bit of space for them so that if they're upset by the investigation, that there won't be further negative consequences to the claimant. Training, we want to make sure there's training required as required by the law. We need to provide training even if it's not required by the law. Implicit bias training is something that we have to treat all people fairly, no matter who they are or how they look or how they act. If I'm a person of color, I cannot treat the other people of color on my team differently than any other type of person. If I'm white, I cannot treat white people better. If I am, if I have a certain ancestry, I cannot prefer the people of my ancestry over those who have a different ancestry. So all those things come into being a supervisor. You have to be fair no matter what. Interaction with certain groups, we kind of went over that as we talked about the different groups that are out there. You have to interact with all types of groups exactly the same as a supervisor. Just because someone has transitioned from one gender to another, you cannot treat them differently now that they've transitioned. Bystander intervention, that just means we need to talk about subordinates. If they see something, they need to report it. They can't just assume that somebody else will take care of it and it'll go away, or that it's not that bad. A lot of times when we do an investigation, we'll come to an employee and be like, oh yeah, I saw that happening, but I didn't think it was a big deal. We need to keep all training records and make sure that employees as well as supervisors are trained regularly, and keep it available in multiple formats so that we can produce it when it's asked for. That just means if we do keep it online, that we have it several different places so that if we need to print it out and submit it somewhere, we're able to do that. We wouldn't want to save it and then not have it available if we ever needed it to prove that we've done training. So all the policies and training has to be reinforced by leadership. Managers and supervisors have to understand that their adherence to the standards of the law and internal policies are required. And as managers and supervisors, we should be the examples. We should model the desired behavior and provide appropriate support to managers, supervisors on the front lines, to our employees as well. So here's the resources that the items from this training were taken. That's the dfeh.ca.gov as well as the EEOC. Here's some legal references that are thrown in there to referring to California Code. Unlawful for an employer, labor organization, employment agency, apprenticeship training program, any training program leading to employment, or any other person because of race, religious, creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, age, sexual orientation, military or veteran status, to harass an employee, applicant, unpaid intern, volunteer, or a person providing services pursuant to a contract. Another piece of the code here. For purposes of this subdivision only, employer means any person regularly employing one or more persons or regularly receiving services of one or more persons providing services pursuant to a contract, or any person acting as an agent of the employer, directly or indirectly, the state or any political or civil subdivision of the state and cities. Another piece of the code. For purposes of this subdivision, harassment because of sex includes sexual harassment, gender harassment, harassment based on pregnancy, childbirth, or related medical conditions. Sexually harassing conduct need not be motivated by a sexual desire. One last piece, the code here that we're going to look at. Unlawful for an employer, labor organization, employment agency, apprenticeship training program, or training program leading to employment to fail to take all reasonable steps necessary to prevent discrimination and harassment from recurring. So abusive workplace conduct. The Fair Employment and Housing Act makes it unlawful to engage in any behavior that any employee finds demeaning. Abusive conduct, conduct in the workplace that a reasonable person, and that's actually a legal term, a reasonable person, would find hostile or offensive, and unrelated to an employer's legitimate business interests, including repeated infliction of verbal abuse, the use of derogatory remarks, insults, epithets, verbal or physical conduct that reasonable person would find threatening, intimidating, or humiliating, their gratuitous sabotage or undermining of a person's work performance, and in this case, abusive conduct, a single act shall not constitute abusive conduct unless it's especially severe and egregious. Let's talk about another scenario here. Jason, he's a new employee and he works at the authority. He's having difficulty learning office protocols. He asks his supervisor, John, for assistance. In a loud, sarcastic voice, audible throughout the open workstation area, John tells Jason, "You must be some kind of special. I've shown you how to do this impossibly simple, simply simple, 3 simple step procedure over and over and over. You should have been paying attention. I won't show you again." Well, can Jason sue John for abusive conduct? Should Jason just have paid better attention earlier? John's actions constitute abusive workplace conduct, can likely be disciplined for a violation of workplace behavior and policies. Does John's conduct expose the authority to liability for unlawful discrimination? Well, I think John's actions constitute abusive workplace conduct and can likely be disciplined for violation of workplace behavior policies. As far as we know, John did not discriminate for any condition or protected class that Jason may have been a part of. Well, it continues. John writes an email to Jason, and it reads, "Jason, out of curiosity, are all Irish mutts as stupid as you? What is it about the thick potato head of yours that you simply can't understand the most simple of instructions?" So now it's become severe and pervasive, right? Because it's continued. So can John now be found personally liable for harassment based on race, ancestry, national origin, or mental disability? Yeah. The employer is strictly liable for the harassment by John because John is the supervisor? Yes, also. Can John recover damages from John personally? Can Jason recover damages from John personally? Yeah. All those options are a definite possibility. Under FEHA, above options are all possibilities. So, no independent cause of action. Abusive conduct or bullying in and of itself is not a violation of the FEHA unless it can be shown to have been substantially motivated by a protected characteristic. And that would be one of those 17 points that we talked about. Possible Ralph Act claim of if violence or a threat of violence is involved. And the Ralph Act just provides for civil penalties up to $25,000 in fine for perpetrators of hate crimes. The DFEH does have jurisdiction to investigate and litigate if it's a Ralph Act claim. Possible non-FEHA claims like assault, battery, or intentional inflict of or personal distress, those would probably just be law enforcement. And anytime you're charged with assault, that doesn't go very well. So let's review. Don't harass. Hostile work environment, once again, just one last time going through it. Making an unwelcome sexual advance or any other verbal or physical conduct of a sexual nature with the purpose of or that creates the effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. This type of harassment typically comes from coworkers. We looked at all these different types of sexual harassment, and as supervisors, we need to be aware. Unwelcome advances. As a supervisor, you're held to a higher standard. Never request sexual favors. Never imply. Never make jokes about it. Because the very implication could be sexual harassment. Other verbal or physical conduct of a sexual nature. Remember that word, severe and pervasive. When we talk about sexual harassment, quid pro quo, it does not have to be severe and pervasive. But for other types of things like the interruptions where we talked about in that scenario where you had some workers that would burp and interrupt the meeting, only if that would be severe and pervasive would that be a problem. Making threatening reprisals after a negative response to sexual advances. So if somebody turns you down on those sexual advances, so hey, we should go out. Threatening reprisals after they say no, that would be illegal. Leering, which we talked about, sexual gestures, displaying of suggestive objects, pictures, cartoons, or posters. Anytime it unreasonably interferes with an individual's work performance, we create a hostile work environment. We have to focus on the impact of the behavior, not the intent, but the impact of the behavior. For sexual harassment, sexual desire is not a component. And once again, there's that quid pro quo. This for that, the type of harassment that happens when a supervisor or other authority, and that can be real authority or perceived, through words or actions, that they must engage in sexual conduct in order to advance or not receive poor treatment. Conditions and employment benefit or continuing employment on the employee's willingness to perform sexual favors. Anytime there's any harassment, it needs to be reported. It can be reported internally, and it can also be reported to us at ZAMP HR. Contact us immediately. You can use 801-377-1190. You can also use toll-free number 888-819-5952. If any employee observes sexual harassment by another employee, any supervisor observes by another supervisor, any manager, any non-employee, it needs to be immediately reported so that we can take care of it immediately. Appropriate action will also be taken in response to violation of policy by any non-employee. We care about sexual harassment because as supervisors, we're personally liable. Okay? As employers, we're personally liable. What we want to do is we want to make sure that we limit liability for ourselves and for the company. The law of negligence defines that a standard is a level of care that a reasonable person would exercise in a similar situation. And we talked about that reasonable person a little bit. It's reasonable for a motorist to follow traffic laws, including the speed limit. In this case, and in the law, the reasonable person is not an actual person. It's just a phrase that's used in criminal and tort law to denote a hypothetical person in society who exercises average care, skill, or judgment in conduct, and serves as a comparative standard for determining liability. Other hypothetical figures in law could be the right-thinking member of society, the officious bystander, the reasonable parent, reasonable landlord, fair-minded and informed observer. So, I appreciate your participation. Hopefully, you've gleaned some useful information through this. Understand the elements of sexual harassment and that there are remedies available to victims of sexual harassment under California and federal law. Other forms of unlawful discrimination, harassment, and retaliation under the FEHA and other statutes are enforced by the DFEH. Strategies for preventing and responding to unlawful discrimination, harassment, and retaliation, and abusive conduct in the workplace. A couple more FEHA facts as we're wrapping up here. Remember, an employer is strictly liable for sexual harassment committed by a supervisor or an agent of the company. All employers, sole proprietors, contractors, etc. are liable for sexual harassment under the FEHA. And sexual desire is not a required element of sexual harassment or a sexual harassment claim. Please reach out to us if you have any questions. I can always be reached at those numbers above, 801-377-1190. You can also reach us at hr@zamphr.com. Let us know if there's anything else that we can help you with as supervisors, or if you have any scenarios that you'd like to discuss. Thanks for your help, and thanks for your participation.